Immersive games are redefining how we play and how we live. But as virtual worlds grow more lifelike, who's responsible when things go wrong? From biometric data and dark patterns to child safety and digital property rights, regulators are stepping in fast. Can developers keep pushing boundaries without crossing legal lines? Find out in Gamma Law's Immersive Gaming Legal Primer, your guide to balancing innovation with consumer safety. Virtual, augmented, and mixed reality, VR/AR/MR, are transforming how people learn, work, and play. The industry is projected to skyrocket from $3.1 billion in 2019 to $57.5 billion by 2027. But this explosive growth brings heightened legal and ethical responsibilities. As players step into hyper-realistic digital environments, developers must protect users' privacy, safety, and mental health. Governments and regulators are increasingly treating immersive games as serious consumer products, not experimental entertainment. Lawsuits are emerging against developers accused of intentionally making games addictive. Regulators like the FTC now view manipulative design tactics, especially those targeting young users, as potential violations of consumer protection law. The 2024 case against a teenage VR developer accused of exploiting psychological triggers highlights the tension between creativity and responsibility. Courts are signaling that addictive design can trigger liability, even for independent creators. Federal and state consumer laws, including the FTC Act, California's CLRA and UCL, prohibit deceptive or unfair digital practices. Together, they form a robust framework that now extends to immersive experiences and virtual marketplaces. The COPPA Act and California's privacy statutes demand strict consent and transparency when collecting data from children under 13. Developers must design youth-facing games with built-in privacy controls and parental oversight mechanisms. Modern XR platforms gather intimate information, from heart rate and eye movement to facial expression tracking, in the name of realism. This creates new privacy risks that traditional data laws were never designed to handle. Illinois' Biometric Information Privacy Act, BIPA, requires explicit consent before collecting or storing biometric data. Laws modeled after BIPA in states like California and Texas are reshaping how immersive developers manage user data. BIPA and related privacy lawsuits have already resulted in settlements totaling hundreds of millions of dollars. For immersive gaming startups, even a single data privacy violation could be financially devastating. If you found this analysis useful, hit like and subscribe to Gamma Law for more updates on gaming, digital assets, and emerging tech law. The Fourth Amendment's protection against unreasonable searches now extends into the digital world. Courts are beginning to apply these principles to immersive environments, creating a new frontier for constitutional privacy rights. Legal compliance is the starting point, not the finish line. Companies that invest in encryption, anonymization, staff training, and transparent user consent systems will not only avoid penalties, but earn player trust and market credibility. Organizations like the ESRB and Interactive Advertising Bureau (IAB) are setting voluntary ethical benchmarks. Developers who align with these standards can demonstrate leadership and reduce the risk of regulatory backlash. Regulators are cracking down on design elements that trick players into purchases, such as hidden fees, pre-checked boxes, and misleading limited-time offers. Each deceptive act can lead to fines exceeding $50,000 per violation. Loot boxes and randomized rewards are now under global scrutiny. Developers must disclose the odds of winning, provide clear purchasing information, and avoid psychological manipulation that targets vulnerable users. As immersive ecosystems merge hardware, software, and marketplaces, they risk running afoul of antitrust law. The Sherman and Clayton Acts prohibit anti-competitive practices like exclusionary design or walled garden economies. When hardware like VR headsets causes injury or sensory harm, product liability law applies. Regulators in the US and Japan can hold manufacturers accountable for defective design, poor warnings, or failure to recall unsafe devices. Players now expect persistence for virtual assets, NFTs, skins, and in-game property, even after a game ends. Developers who enable portability and interoperability will be better positioned as regulators codify digital property rights. Abuse and harassment in immersive environments are increasingly recognized as real harms. Developers must implement robust moderation tools, reporting systems, and sanctions to protect users and reduce liability. As in-game currencies gain real-world value, financial regulators are taking notice. The CFPB's proposal to expand electronic fund transfer protections to virtual currencies marks a key step toward treating virtual economies as financial systems. Immersive gaming is entering a new legal era where innovation must coexist with accountability. Companies that engage experienced legal counsel early and treat regulation as a roadmap rather than a roadblock will lead the industry into a safer, sustainable future. In gaming, every move counts, especially the legal ones. Head to gammalaw.com/contact and talk to Gamma Law about keeping your innovation compliant, secure, and future-ready. Want to dive deeper into the laws shaping immersive gaming and the metaverse? Click the playlist right here to watch the full series of Gamma Law Insights.